you do? Just take a chance? Roll the dice?
You take the chance. The attorney doesn't. Most lawyers will say to you something like, they can give you a fairly decent opinion on whether what you're going to be filing is going to be violating the no contest clause. But it's not a guarantee. You don't know for sure. And again, there's the no contest clause is still a threat, because even though it might not be a contest, and even though what you're filing, there may have been probable cause for it, even if it was, and therefore there was no violation of the no contest clause, you can't know that for sure. And so you might be putting at risk, but it depends on what you're putting at risk. If somebody left you $5,000 or $25,000, but if you successfully contested the will or you successfully did something else, you might get $5 million. Well, that's not much of an issue for you, is it? On the other hand, if you're a poor person, you might not be able to afford to run the risk of losing that $25,000. It depends. It's pretty much got to be analyzed in each individual case.
Okay. So, for a surviving spouse or a child of a decedent, what rights are there irrespective of the terms of the decedent's will or trust? What are they entitled to?
Well, it depends upon a little bit. Now, there's actually 3 types of ways that people can wind up dying.
Okay.
They die without a will or a trust called intestate succession.
Yes.
They die with a will or a trust called testate succession. And it can either be done by way of a will, which has to be probated to work. You have to get actual court orders to make it work. Or a trust, which is self-executing. The trustee can simply write the checks and do the other things he's supposed to do under the trust. Now, let's say that the wife has left nothing. Well, under the probate code, whether it's a intestate succession or a will, she can get a couple of things automatically. She can get a family allowance. This is kind of like post-death spousal support, where she gets the difference between what her expenses are and what income she has during the entire period of probate. And again, that happens whether you die intestate or with a will. There is something called a probate homestead, which gives her the right to live in the house for a period of time that could last her entire life, depending upon how long the marriage was. Again, that applies if you die intestate or with a will. But if you have a trust, you don't get family allowance and you don't get a probate homestead. Now, again, I say that assuming that all of the property has already been transferred into the trust. You might say, well, what do you mean by that? Well, one of the major differences between a will or a trust is that a will operates on theoretically everything you own in your own name. A trust only operates on what you put into it. What do you mean? How do you put it into it? You put it in a box? No, you don't. In order for Mike Gray to have a trust, he needs to transfer his house from Mike Gray to Mike Gray, trustee of the Mike Gray Trust. Now the Mike Gray Trust owns the house. And it's that kind of thing that is then sheltered, if you want to call it that, from family allowance, probate homestead, and other such things. Keep in mind, this applies, these things are available to spouses and minor children. Adult children, generally speaking, don't get any of these things, even if you died intestate or with a will. The surviving spouse, especially in California, has one other major issue, and that is that property might be community property, even though it was titled in her husband's name. The longer you're married, the more likely there is community property. Whether there is or not depends upon a number of things. How long you were married, what property you each owned before you got married, whether either one or both of you worked after you were married, whether you inherited money, which would be separate property, and whether or not any particular spouse can trace property back to a community property or separate property source. That is a benefit that runs in favor of the surviving spouse, because she can always make that kind of community property claim.
Okay. Now, sort of related to these things about sorting out, what's what. So one, I guess I'll say I understand that you can sort of include things in the trust by just attaching a schedule, listing it.
You can do what's called a affidavit or a schedule that usually says this. On the first page of the trust, it says, the trust estate currently consists of the things listed on Schedule A. And Schedule A could be a list of things like our house at 123 Smith Lane. Now, the actual deed on file may still say Michael and Mrs. Gray. But for purposes of administering that as an asset of the trust, if Michael passed away and Mrs. Gray wanted to put it in the trust, or officially in the trust, or not officially is a bad word, record title in the trust, she would file what's called a Hegstead petition. And she would file a petition with the probate court, give 30 days notice, and say to the court, the trust says this is an asset of it. I want a court order that officially recognizes that, so I can then either sell the house as the trustee, borrow against the house, whatever. And so yes, if you don't go ahead and actually change the deed, you can still put it into the trust by filling out the Schedule A that's on the back of the trust.
Okay.
Part of the problem with that, Mike, is that when people set up their trust, they usually list their assets on Schedule A, but as time goes on, you sell some things, you buy some new things, and when you buy that new house, you think, there's something the lawyer told me, God, 10 years ago, when I buy a new house, I should title it. I forget.
Yeah.
And you just take it in your own name.
Yes.
That's a problem.
Yes.
Because then the only way to get that house into the trust is to probate it through what's called a pour-over will, so that it gets transferred into the trust.
Right. And then you don't save your probate costs.
So you have to pay probate fees on the pour-over will to probate it.
Right. Now, another type of way that people own property is like joint tenancy with a right of survivorship, or community property with right of survivorship. So what happens with those?
Well, basically, if I have a bank account that's in joint tenancy, either one of us can pull the money out at any time we want, whether we're alive or dead. Sometimes there are things called pay-on-death accounts, where it's in my name, payable on death to Michael, or what used to be called cotton trust accounts, which
Right.
is I'm the trustee for Michael, but it's really my money. Those, pretty much all you need is a death certificate. You go down there with a death certificate showing I'm dead, you take out all the money. Community property is also recognized as something that if the widow waits 30 days, she can record a document that then takes her husband's name off the house and puts it into her name alone.
If it's like a right of survivorship, I guess.
Exactly.
Yeah.
Well, community property implies a right of survivorship.
Okay,
but-
but unless there's like a document, like a trust or a will that directs my share of community property, right?
Correct. Now, if you've got a will or a trust, then it's good.
Yeah.
Your half of the community property is going to go to whomever you leave it. You could have a wife and 16 children, and you leave your half of the trust to anybody you want to, or I should say, your half of the community property.
Right, but I guess what I'm getting at is, if I have, let's say I don't have this schedule attached to my trust, and I've got a will, but I happen to have a home that I bought, and it says community property with right of survivorship. So doesn't that sort of bypass the trust and the will?
Well, I think we're using a term that I'm not sure I would agree with. The term
Okay.
community property is usually mentioned sometimes on, is often mentioned on the deed. It doesn't really say community property with right of
I
survivorship.
think that was it's a newer form of title.
There is a new form of title that I'd heard referred to as community property with right of survivorship, and I suppose in that case, it would control over the will or the trust. Let me give you
Okay.
an example.
All right.
Joint tenancy, by definition, involves a right of survivorship.
Yes.
If we own a piece of property as joint tenants, and my will says when I die that my joint tenant interest goes to someone else, the joint tenancy title controls over the will.
Right.
You get it, or I should say my interest evaporates and you then get the whole thing, no matter what my will or trust says.
Right.
With community property with right of survivorship, I believe the argument is that that's the same thing.
Yeah. Okay. All right. Now let's say I have to take my executor or a trustee to court. Can I recover those legal fees?
Well, again, it depends. Generally speaking, America is different than England. England, the loser pays.
Okay.
In America, you pay your own attorney's fees. There are exceptions. If we have a contract and it says if one of us sues for breach of the contract and loses, he pays the other one's attorney's fees. There are some state statutes that deal with the allocation of attorney's fees. By and large, no. If you remove the executor, you pay your own fees. However, let's say that there are 4 beneficiaries or even 2 beneficiaries. You're one of the 2. You go out and get a lawyer. The other beneficiary doesn't. You're successful in removing the executor. There's something called the common fund theory, which says that you can then petition the court for an order that your attorney's fees be paid out of the estate or the trust, because otherwise the other beneficiary would get a free ride. And then you would wind up getting the money out of the estate. Now, of course, it's still coming half out of your own pocket.
Right.
And you might say, well, is there a way to get my attorney's fees paid by the executor that I got removed? And yes, there is. It depends upon the nature of his breach of fiduciary duty, whether he acted in bad faith, whether he acted without substantial justification, whether he did an accounting that you were able to successfully challenge. In those cases, the court might order